at Haifa University, Faculty of Law. His main area of research is refugees and migration, and his book, Humanity at Sea, Maritime Migration and the Foundations of International Law, came out with Cambridge University Press in 2016. In addition to his academic work, he has been and is still involved in a number of advocacy initiatives aiming to protect the rights of refugees and migrants, both in Israel and abroad. And he has recently co-authored a letter to the Israeli Attorney General, signed by leading Israeli academics, arguing that the arrangement to deport Eritrean and Sudanese asylum seekers to third countries is illegal.
Okay, thank you so much, and thank you for this panel. They also invited us to reflect a little bit on our own involvement in this area, which I will take an opportunity of, although it's a little bit of a self-indulgent thing to do. And my justification here is that my involvement really starts with as a student in the clinic about a little bit over a decade ago. And I was one of the teachers that got me, the lecturers, the instructors that got me very, very interested in this field. And as Nathalie said, I ended up doing a lot of research in this field. Now, I want to start from this moment by saying we're talking about, as I said, a little over a decade ago. And this is the moment when, as Anat said in her comments, this issue started to arise as a major policy issue in Israel. And I think that when I reflected towards this panel about that period, what was most clear to me was that we had a very different understanding of this field at the time in Israel. And primarily, I don't know if you agree or not, but that's my recollection, the understanding was that it was an open, to some extent an open field. That it was not yet clear at all where the Israeli government will go to with this, what are the obligations under the 1951 Refugee Convention, how they will be interpreted and implemented. And since we see a very clear trajectory that has legal as well as non-legal components, when I'm saying non-legal, I mean, for example, the building of a fence on the southern border in 2008. But both these kinds of components build towards the single trajectory of closing the borders of Israel to refugees and asylum seekers, and also making this country a country that basically does not accept refugees and asylum seekers as part of its fundamental obligations under international as well as domestic law. So it's a grim trajectory. But to some extent agreeing with Shani, and even going perhaps a little bit further than her, I think this trajectory is not uniquely Israeli. And I think it is really a trajectory that characterizes the development of this field over the last 2 decades, the world over, and especially in Western developed countries, whatever you want to call them. So, going back to my own kind of experience, we started by representing individuals as a student in a clinic, and then as a beginning lawyer. In this period, we're talking about 2007, 8, 9, it felt like things are very open. There was a lot of lack of legal regulation. It was very easy, relatively speaking, to set people free from detention that was for deportation purposes at that time. And it was very kind of clear that this is just the tip of the iceberg of a global phenomenon, which in my own research I then started to think of in other parts of the world. And if you think of this as a global phenomenon of what we're confronting now in this country, a real question that arises is, where should we start? Where is the beginning point of the kind of contemporary reality that we're living in? And I think that for our purposes today, we need to think about the development of bilateral and multilateral agreements for the external enforcement and for the enforcement by proxy of international borders. So some of you may be coming from European countries, and if you're coming from European countries, you are familiar with the term externalized border enforcement. And the idea basically is that a developing country is taking obligations, is taking authorities to enforce a developed country's border from afar, whether through actual use of military or police force, or through kind of accepting back people. Readmission agreements are really normally talked about in the inter-European context, but there are other agreements that are similar also in the European kind of African context. And in particular, we need to look at the border, the kind of fault lines between the developing and the developed world. If we look at the United States' policies in the Caribbean that are, the border between very rich and very poor parts of the world, we look at the borders between Australia and Southeast Asia, we look at the border in the Mediterranean between Africa and Europe. These are all the kind of border between the extremely rich and extremely poor parts of the world, and these are where these policies are generated. Now, Israel in this context is unsurprisingly located in a very important geographical and kind of political place. And for this reason, Israel was, in comparison with other developed countries, kind of late to the game in many regards in terms of these policies. So when we're talking about 2005 or a decade ago when this problem starts, in the European, in the Australian, and in the United Statesian contexts, we already have enforcement by proxy that is well in place at this time. And Israel did not respond as early, perhaps because it was exposed to this migration later. But it is very quick to kind of catch up with the game. And I think it is also correct, and Shani shows this in a very good recent article of hers, that Israel is now also, as in other parts of other forms of legal policy, becoming not only a learner and not only a receiver of these kinds of policies, but also, to a certain extent, an exporter of such policies. Let me start by the non-legal policy that I talked about, the 2008 fence in the southern border of Israel. So this was a very big pride, as you know, of our current Prime Minister, who was Prime Minister back then as well, and he was quick to take credit when the current U.S. President took up this as a plan, and of course President Donald Trump also was happy to give him back credit. But this is just this is really just a minor point in comparison with the so-called third country agreements, which are a kind of innovative construction in terms of being bilateral agreements for housing and processing migrants and refugees that are not only failed asylum seekers, but also asylum seekers that will be kind of processed by proxy according to what was the plan, and the very important part of the kind of enormous secrecy and the very clear and kind of, I think, well published in the media, financial incentives that are built into this legal institution that Israel created with these two countries. Okay, so in terms of attacking this framework, I'm going to be done in a second, under international law there is a dilemma. On the one hand, you see many precedents in the international, transnational sphere that seem to be relevant, that seem to be possible from the perspective of the government to think about as precedents that are also actually not that different and maybe give grounding for the new Israeli development. But on the other hand, and I think this was what became most clear in the context of writing this legal opinion in the name of international law professors in Israel, it really calls us to ask very basic and fundamental questions about what is international rule of law mean today in terms of basic foundational values such as, once again, good faith, transparency, and human rights, not only in the sense of non-refoulement, per se in the most kind of minimal and bare-boned notion that is based on the Convention Against Torture and the Refugee Convention, but also human rights more broadly, procedural rights, the rights for access to enforcement mechanisms. All these, I think, will be very important when I believe we will confront the point when a new framework that is not that different will be tabled and provided for our discussion and for the court's review. I'll leave it at that.